Neal Salisian. I'm pronouncing that right?
That is correct.
Okay, because cause sometimes I say a name and I think, wait a second, no one ever corrects me, but that seems about right.
If you get it phonetically, it's Cilician. So some people want to
Mm-hmm.
skip an I or make an I into an E because there is a Salesian monk
Ah.
delegation as a Salesian high school
Mm-hmm.
with an E, not an I. So it's Cilician is correct.
All right. Well, so far so good. So far so good. So I just want you to know that I actually shaved for this, so I'm a little bit disappointed. I didn't wear the suit and tie. But so this is a little bit. I expected the clean cut Neil to arrive. Instead, I've got the.
It's my beard. It's clean cut beard, actually. I shaved down
Yeah,
here, but I like to carry a nice light beard.
yeah, yeah. I'm not saying you're not pulling it off. You're pulling it off like crazy. You're like it's like a madman. So, how many years have we known each other? It's been like well over 10. It's got to be.
Hey, yeah, a dozen is probably a fair guess.
Mm-hmm. Yeah. And so we haven't seen each other as much. Whenever we do, it's always great to see you.
Likewise.
I know that you're a top litigator when it comes to real estate, and which means you like to argue, right?
Love it. That's why I got into practicing laws. I wanted to find a way that my arguing skill and passion could be translated into profession. And that's how I landed on litigation as a lawyer.
Mm-hmm. Very good. And the focus is mostly real estate, or do you do business as well?
Both. It's mostly real estate, but real estate is essentially a subcategory under business disputes. There's a lot
Fair
of
enough.
businesses. There's intellectual property, there's labor and employment, real estate. These are all categories that involve usually business issues. And so we focus within business disputes on real estate litigation.
So growing up, were you the one? I mean, do you have siblings? I mean, were you growing up, or were you the one that was always causing a ruckus?
Yeah, I'd say so. I have an older sister, and
Uh
she
huh.
kind of followed the rules a little more closely than I did. And my dad was a very interesting guy. He was not a lawyer, but probably should have been. He was a financial manager, and he probably should have
Okay.
been a lawyer because he was excellent at arguing, excellent at making points. And so I learned a lot from him, and
Mm-hmm.
go head to head quite a bit. And I think I built up some of my resistance and my strength in arguing, and kind of a concept on how to think and how to hold
Mm-hmm.
yourself based on my relationship with him and how we interacted.
So what was his style? Was he, because I've noticed if I refer a real estate attorney, obviously they got to be amazing, but it's finding the right fit
Yeah.
for someone. Because some of them, I mean, I'm not going to mention the names. Like some of them, you have the old school, real seasoned guy that just talks like this, and he just calms you down. And then there's guys that you go like, you know what? I need a shark to come in here and just attack because these guys are taking advantage of this, this, this. Where do you land in that? Do you think?
So I'm real strategic. And so I have the ability to be the shark, the super aggressive lawyer, but I also have the ability to kind of be the friend and as opposed to the foe, sometimes the opposing counsel. And I think
Mm-hmm.
to be a really good litigator, you need to be more of a chameleon and be able to
Mm-hmm.
do both. If you're just one type of person or one type of personality, it'll work on some cases, but it won't work on all of them. And so I try to make sure that I have the ability to succeed in every case I have. In some cases, being ultra aggressive and relentless is the way you win a case. And in some cases,
Mm-hmm.
it's the opposite, being very strategic, letting the other side think that you're the nice guy or the friendly person.
Mm-hmm.
You can slip in some evidence that they won't notice because their guard is not up. So there's
Mm-hmm.
situations where you need to be a different type of person. So I think being a chameleon, being able to adapt to your surroundings, I think is the most
Right.
important characteristic of a good litigator.
Yeah. I always look at it kind of like a dance. It's like, what kind of dance is it going to be? And you got to see how your partners, who you're going up against, is going to dance. And sometimes you guys can work it out. Everyone's reasonable and you can figure it out. Sometimes you know that I got to meet this guy or man or woman right here because that's the only language that they're going to speak.
Right, exactly. And when I hear some people ask for, well, I need an aggressive lawyer, I think to myself, do you really? Are you sure? Is that what you need in this
Mm-hmm.
situation? Because the lawyers that I encounter as opposing counsel that are just aggressive all the time, they usually
Mm-hmm.
miss the mark. They're usually
Mm-hmm.
doing their client a disservice in some way that they don't realize.
Right.
I see it. I know that they could do a better job against my case if they had taken a different approach.
Mm-hmm.
Because oftentimes when someone's really aggressive with me, I'm always going to get more aggressive than them. That was kind of my dad's way. Whenever somebody would come heavy at him, he would
Mm-hmm.
double it. If they come double,
Mm-hmm.
he'll quadruple it.
Uh-huh.
So when I had the similar mindset that someone's coming after me in a super aggressive way, I'm probably going to be double more aggressive against them, which is just going to
Mm-hmm.
harm their client, and it's going to be harder
Right.
for them to achieve what they need to achieve. They come at me
Mm-hmm.
in a softer, more measured approach. They're more likely to get a better result for their client. But some lawyers just don't understand that concept, or at least don't know how to interact with me.
No, no, I get that, and that's extremely well put. So, speaking of being aggressive, do you have any case that you recently that you just said, you know what, this other side of me has to come out right now? But you can share any story you want. But
Yeah.
I'm just thinking, that this may be kind of fun to hear about the other side of you.
Yeah, I think it kind of goes to my side of me I mentioned where I'm strategic. I'm always trying to think
Mm-hmm.
about the best way to handle a case. And since I know you're the Valley real estate expert, I have a couple, at least one or two good stories about real estate matters that actually took place in your backyard in the Valley. Uh,
Great.
the first one I have is for you was a case where I was brought in by a homeowner who was sued by a bank regarding really a basic case. They just didn't pay a loan that he took out on a piece of property, but it really wasn't that simple. There was a developer in and around Santa Clarita who was trying to do a 30 home development, high end residential homes, probably think 4,000 square foot custom homes, all 30 of them. Went to a well-known bank to obtain financing to do the development. Couldn't come up with the financings, but the banker came up with an alternative kind of crafty idea, a way around this, which was to have all the 30 potential buyers take out lot loans for these empty
Okay.
lots at $500,000 a piece, and then give all that money to the developer, who will then use those funds to actually build out the project and service those lot loans while the project is going on. So it sounded fine on paper. All these properties were set up with lot loans. The one issue is that they needed a comp for the land to explain why it was worth $500,000, because the land was empty, worthless land.
Mm-hmm.
And so the developer actually sold a few of the lots to his family and friends at $500,000.
Mm-hmm.
Therefore, the bank had some comps that they could work with to make it work. So they went forward with this.
Nasty.
Yeah, got some comps. They issued
Mm-hmm.
30 these $500,000 lot loans, and everything was going to be great, except the developer went bankrupt and couldn't finish the project, and really
Mm-hmm.
was just unable to do it. Probably wasn't able to do it from the get-go. There was no really due diligence that my client did on this developer, whether they were going to be in it for the long run or not. Developer disappears. No development is made. The loans that were being paid, monthly payments are being paid by the developer, those obviously stop. So now the banks are upset and they want to get paid. And so they start pursuing the borrowers, these different 30 buyers. Some of the
Oh, that's
buyers filed for bankruptcy. They couldn't make the payments on it. Some settled for a partial payment and maybe paying off the loan over a longer period of time, or they got a small discount off the 500,000 and just paid it to the bank. But my client wasn't in a position to do that and didn't want to do that. So it was actually two or three of them. They hired me to defend the bank.
Mm-hmm.
And what we did in that case to defend it was we raised the anti-deficiency statute. Now, in
Mm-hmm.
California, what the anti-deficiency statute holds is that a lender of a single family purchase mortgage in California, they can't go after the borrower for anything beyond just a security, which is the home. So they can
Mm-hmm.
foreclose on the home, but if the money they get on that foreclosure is less than what's owed on the loan, they eat it. They eat the difference, which is why lenders
Mm-hmm.
always want to make sure that there's sufficient equity when they're lending money on the
Sure.
property. But that statute only applies to purchase money and for a single family home. And neither of those applied here because it wasn't really, you weren't buying a home and there was no home. It was a piece of land. It was a lot. So we went to trial, and at trial, we were able to establish that the banker, remember the banker that came up with this whole idea in the first place,
Mm-hmm.
he knew the intention of the money was to have a completed home on those lots. So they knew that the goal of the money was not just to buy a piece of land. The goal was to have a completed home on the lot.
Mm-hmm.
That's what the borrowers were intending when they borrowed the
Right.
money, and the banker knew about it. And that was the key. That was the key connection. was that the representative of the bank knew about this. So the trial court ruled in our favor and said the anti-deficiency statute did apply. And then therefore our client was not personally liable for the loan beyond the security. Now these lots were foreclosed on for $10,000, $15,000, $25,000. There's a massive amount of deficiency, but because the court applied the anti-deficiency statute to these situations, my client never had to pay anything. In fact, the bank was forced to reimburse my client for all the attorney's fees that he and they had spent in defending the lawsuit. And actually it created a new law in California that a lender's intentions can be relevant to determine whether a loan falls under that anti-deficiency protection. So it was really backfired quite a bit for the bank, all because of this banker that went rogue and was trying to do it, probably arguably a pretty shady deal with that developer in the hopes of getting that commission.
Especially if he's giving, he's giving out $500,000 knowing that's not even worth 100.
Correct.
I mean, that just, then you got like a fraud element there almost.
Well, I mean, if the properties had been built and they had been completed, they would be worth more than that, obviously. But they were lending on something. It was basically a quasi-construction loan of sorts they were doing. But construction loans require much more regulatory requirements. There's much more in the way of analysis that needs to happen and review, and the banker didn't want to go through all that process. And so a lot loan's much easier. It's just money on a blank piece of land. And so probably went that route for the ease of the due diligence requirements.
So what if, so you've got this guy that couldn't afford to pay it off, and he's being like strong-armed, but then he's got to hire you.
Yes.
But so how do you determine, I mean, how do you advise someone? It's like, okay, look, we're most likely going to win, but we're going to be in front of a judge, and we're going to be in front of a jury, and we never know what's going to happen. And I charge $800 an hour, whatever it happens to be, right? So how does a guy make that decision when he hires you or when he doesn't? Because it's a lot of risk to hire you. It's a lot of risk not to hire you.
It is, yeah. And I think that's a good question to ask, because in certain situations like this was actually kind of a long shot, because the anti-deficiency statute had never been applied in a situation like this. There have been some corollary similar cases where there was one case where a piece of purchase money mortgage was made and the house was never completed and it fell off into the ocean, and there was a lawsuit over that, and that was somewhat similar where the borrower prevailed, but nothing like this before. So in this situation, my client just felt he was wronged. He and the other two people that hired me felt like this wasn't fair. They would have to pay money on this loan when there never was the intention of them to just take a lot loan out. And so they felt kind of emboldened by that fact that they felt it was unfair, and they felt that the law should conform to fairness. It often doesn't, but in this case it did. So it was a risky decision on their part. But I think at some point, particularly when we took the deposition of the banker, as we got further and further along, our confidence started to grow, and the client became more and more committed to seeing through this matter out through litigation, because the bank did try to throw everything they could at us to make it more costly and more inefficient as much as possible. But again, because of our experience in knowing how to deal in these situations and how to run things efficiently, we were able to dodge a lot of those hurdles and different litigation tactics that the other firm deployed. The bank actually ended up trying to hire different counsel along the way, and more lawyers in different ways when they saw this thing going sideways. Where they made the real mistake was ultimately I mentioned this became California law. They actually appealed the ruling by the lower court, the jury's ruling. They probably should not have appealed it and just accepted it, but they appealed it, and then we won on appeal. And by winning on appeal, it created new law in California. And had they just accepted the lower court's ruling, that would not have created bad law for banks and lenders when it comes to the anti-deficiency statute. But I think they got emotionally invested in the case and thought the ruling was wrong, and they wanted to pursue it. But I think that was a strategic mistake on their part.
I don't even know your client, but I like him or her because they wanted to do what was freaking right.
Yeah.
found the right person to do that. And yes, there was a risk, but there comes a point where it's like, God dang it, stop bullying me. And it's,
Exactly.
it's awful when people, I despise bullies. I'll just say that. And when people are doing that and it's their livelihood, and this guy stood up and then had you next to him, that's a real, that's a great story.
It worked out
I
well. I
love
mean, he
that.
got fully reimbursed for every penny of attorney fees he spent. He got
Mm-hmm.
interest on that money, and he got satisfaction of
Good
knowing
for
that
him.
he got the right ruling, and he got justice and fairness, which, to be honest, doesn't always happen in litigation. A lot of times, you don't get justice. And in this case, he
Mm-hmm.
did.
I love it. That's great. That's great. So it could have been a hell story, but I expect that what you're going to do is you're going to open up your shirt. It's going to be a big S, and it's not for Salisian. It's like super litigator.
You know what? I felt that way when we won at trial, and then when we won again on appeal, I did feel like a Superman or superhuman,
That's
just
sweet.
because of the right result from a fairness. It was a stretch in terms
Mm-hmm.
of how the law looks at things, but I think oftentimes you'll find that what really helped us here was the public policy of the anti-deficiency statute. The reason why it was entered was to really protect homeowners, protect people buying homes, and to shift that burden on lenders. Lenders, you need
Mm-hmm.
to do better. You need to be more diligent. You need to not lend out money wildlessly. You're in a better position to
Right.
know what is a good and bad investment or good and bad loan. And don't issue loans to people and be predatory if you can avoid it. And so I think
Right.
the message was that's the message from the legislature when they issued that statute many, many years
Mm-hmm.
ago. And I think the court looked at that and thought that that same public policy interest in keeping lenders
Mm-hmm.
in check and keeping them responsible for the lending kind of pushed the court to extend the statute kind of beyond what it was originally intended.
I love it. I love it. That's a great story.
Yeah, it was a good one.
So, yeah. So what else do you
Yeah,
have?
so
You said you have
I got
another
another
one in the
one for
valley.
you in the valley.
Let's do it.
This one a little bit further north, kind of in a near almost like north of Simi. I had a
Mm-hmm.
client who was a homeowner in a kind of rural part that an area where there was a main highway, but to access the property was access through a side road. There was like a
Mm-hmm.
shared driveway with another neighbor, and that shared,
Those are never problematic, are they?
yeah, exactly, shared driveway with an easement, and it was how both parties
Right.
accessed their properties, except both also had separate, call them fire roads to the main road. Our client would oftentimes mainly use the fire road. The neighbor also would use their fire roads, and no one was really using this driveway, so to speak,
Mm-hmm.
as to access their properties, but it was part of the deeded easement. Well,
Mm-hmm.
it turns out the neighbor wanted to build a much bigger home than was currently on the property, but the setback requirements prevented him from doing so because that driveway was so wide that the
Mm-hmm.
setback was being measured from the wide driveway. And the neighbor wasn't using that driveway. And so he figured, well, we'll just close off the driveway because then I can build a much bigger home on the property because then my setback will be measured from the property line as opposed
Mm-hmm.
to the easement line. So he
Mm-hmm.
started blocking the driveway. He put up temporary fencing. He parked an RV there. He did all these different things. I think he heard about, some laws that allow you to, take away or limit someone's property
Mm-hmm.
if you prevent access. Now, under the law, every lot needs to have an access to a road for safety reasons, for fire trucks, etc.
Correct.
But if that fire road that each house had gave sufficient access, then that easement would not be necessary. And
Mm-hmm.
it could be destroyed if the neighbor were to take it over and my client didn't contest and fight that takeover. Over time,
Mm-hmm.
the law would allow that easement to expire. But we did fought and we sued to stop them. What it came down to was we showed that the fire road each property had, what really was not perfect. It crossed
Mm-hmm.
over a creek in the front of the property. There was a creek there and a little bridge. But during heavy rains, which would happen occasionally throughout the year, the road would wash out completely and it would be impassable for a period of
Mm-hmm.
time until the water receded. And that was sufficient for the judge to rule in our favor and say, no, the fire road is not sufficient by itself. Instead, we need to maintain access to that easement, that driveway that the parties share, and rule in our favor. So we thought, great, we have a judgment in our favor. He has to open up his road. He can't block it with fencing or RVs anymore. Well, if you're very familiar with litigation, oftentimes you find out that getting a judgment in your favor is really not the end of a case. Sometimes it's just the beginning. And in this situation, it was no different. So the neighbor ignored the judgment, didn't move the fencing, didn't move the blockage. And so we were left with a situation of what do we do next? So we had to initiate contempt proceedings. It's kind of a quasi-criminal proceeding where you can bring somebody into court and say, you're in contempt of a court order. The court ordered you to remove your blockages, and you didn't. And so we went to a contempt trial. We prevailed on that as well, too. The judge ordered all of our fees paid and ordered him to go to jail if he didn't move.
Really?
Finally,
I like that.
I think his children got involved and figured this had gone on too far. Let's not go to jail over trying to build a bigger home. And so they finally relented upon having to report to jail. And he finally removed his blockages and removed the RVs. And my client was able to maintain access to the shared road. And so it worked out in his favor. That was a long battle. But it's an example of how these neighbor fights over property lines and easements can get really ugly quickly.
Could they have, let's say the neighbor that did this, that was in contempt, couldn't he have just gone to his neighbor and say, this is what I'm trying to accomplish. Can we move this? Can we adjust this? Or can we get an exception? It seems like there is a much better way to do.
There was.
To be in contempt.
Yeah, that's a great question, because it actually did come up during the process.
It's like, just talk it out.
There was a way to do move the road to an area that wouldn't impact the setback requirements, and he could build his bigger home. But the problem is that there's a large hill in that area, and it would require grading of the hill. For the driveway to go where the hill was, you have to cut and grade the hill down so significantly, and it would be very expensive. And the neighbor didn't want to pay for that because it was on his side of the property. He had to pay for it. He didn't want to have to pay for the grading down the road. So instead, he proceeded down this route. He ended up paying a lot more money when you account for all the attorney's fees that my client incurred that he had to reimburse.
Right.
But at the time, he didn't really have the foresight, apparently, to understand that whatever it was going to cost to grade that land was far insignificant compared to the ultimate attorney's fees he would be on the hook to pay.
Yeah. You know what I think a lot of people don't consider is, and there's an attorney that we network with, you probably don't, you may have met him, but he always says, is the juice worth the squeeze? And because sometimes you're looking at this and you're going, my gosh, why didn't you just talk it out? Why don't you figure out the stress alone? I mean, have you ever been in a situation where someone was involved and, at some point there's just too much stress, so they were willing to give it up, even though they were right, even though they might have won, but the stress was too great, because the older I get, the less stress I want to deal with, and that becomes a part of my decision making.
Yeah, that's right. Almost every case I take on, almost every case I deal with has that component to it. I use the phrase litigation therapy because that's really what comes into play. Sometimes people are very angry and emotional and excited about their matter, and they want to file suit, or they want to, do a cross complaint or be aggressive, and that's fine. We proceed that way, and then eventually, 6 months in, a year in, 18 months, people change their minds. They're not as emotional anymore because it's like you said, it wears on them. It wears on them from a financial standpoint. It's expensive, and from an emotional standpoint of the stress of not knowing what's going to happen next and where's this going to end up. And so, and it applies both ways. Both my clients feel that pressure, and as litigators, we apply that pressure on the other side, knowing the effect it's going to have on the ultimate decision making of the other side.
That's part of your strategy is like, you want to keep on doing this. You want to do this.
Correct. And so some people need that litigation therapy so that they can make a more business-minded, rational decision and take some of the emotion out of what they initially had a strong feeling for. The litigation therapy method kind of brings them down to really what matters and really what's important, and kind of moving on. So you'll see vast majority of what I do ends up settling because of that. 95 or 97% of all business disputes and real estate disputes ultimately settle before they go to a judgment. And that's because at some point in time, both parties decide to make a rational, smart decision and put the emotions to the side. And sometimes they don't, and we go to trial and we get some good wins. And I enjoy being in trial. I love trying cases, so I don't have a problem if that ends up being the result. But it's usually not in either side's best interest to go to a trial.
Right. Well, that's great. Gosh. Yeah. That didn't take long for you to give me some great stories. Just like that.
It's good.
Those are really, to me, I find the conversation fascinating, to be honest with you.
Yeah, I love litigating. I enjoy it. I love the battle. To me, it's like a sport, like a mental sport. I grew up playing a lot of sports. I still enjoy watching and sometimes playing some sports. And I find, litigation as a way for me to carry that same energy and enjoyment and pleasure I have from playing and watching sports into my profession. And so it's also a way I'm able to compartmentalize my work. I mean, it can be very contentious at times. Some lawyers do not do a good job of compartmentalizing that emotion. They envelop it too much and it impacts their normal psyche, and they can't be as good of an advisor because of that. But I think it's really important to separate who I am from my work so that you're able to do a better job. And I can go in there and be a litigator, but I'm a gladiator. I'm a fighter. It's my role, but it's not who I am. I'm still Neal Salisian at the end of the day. I'm a person. And so I can separate those two things.
Well put.
And I think that makes me a better litigator because I can treat it like a game that I'm playing. And that makes me able to take some of the emotion, separate the emotion out of it. And that makes me more effective, I find.
What a way. I like that. It's like Neal Salisian, chameleon, gladiator, real estate litigator.
There you go. I enjoy it. It's a lot of fun. And when you really can separate those two things out and really treat it as if it's a game you're playing, not only can you do a better job at it, you actually get a lot more personal enjoyment, which I do as well too. It's so much strategy involved. There's constantly trying to figure out. It's basically me versus somebody else. Who's going to win? It's like a boxing match, but in the courtroom. And I get a lot of joy out of not winning. I do love winning, of course, but the little strategic decisions on what words to use in an email or what argument to make.
Yeah, I love that.
Questions to ask at a deposition, like those little things I really get a lot of enjoyment out of.
I was talking to a past client, and there was this buyer that came in, and we had already given them the pre-inspection reports, front-loaded all the major stuff. And then the guy still comes back and asks for all of it. I'm going, but you had the termite report. Why are you asking for that? We just went down the list, and he was just playing that game. The family was. So I went back, and it was a divorced couple, but they were surprisingly nice to each other. It's like... Yeah. I work with married couples that aren't as nice, because you guys are real nice to each other. But I called them up and I said, so this is what they're asking for. And they were really upset. And I said, what do you think we should do? I said, look, I know the other agent. I said, this is going to be a lot of fun because we're going to meet these guys where they're at. If they're going to play that, then we're going to do it too. So we're going to do, we're basically going to take off the gloves and we're going to know what's what. And I wrote the email, kind of like you were just saying, and the email was worded, it was vicious. It was like, your client is doing this and he's doing this. He knows this is a renegotiation. This is bullshit, blah, blah. So I just spelled it out. I normally don't. I'm a deal maker. In this case, I knew who we were dealing with because I'd met him several times. And my clients were stunned. They were, God, Scott, you're such an easygoing guy. You don't, no. Trust me, you got to do it this way. I sent a preemptive cancellation. I sent everything, every possible thing. I sent him anything I could do along with the notice to perform. I included this, and this as a preemptive, and they were going like, "What the?" They couldn't understand. So it turns out they get that. They get pissed off, and they come back and they take it as is. Wow. And it was because that felt so rewarding because it was like, you know what? I don't like taking off the gloves. Generally speaking, I like to work things out. In this case, I knew it. And so, yeah, that was fun. That got the juices going for sure.
Yeah, you can get a little sense of what it's like.
Yeah.
Too much can be bad for some people, but I think a little bit of that combativeness, it's healthy.
No, I would totally agree. I would totally agree. So, uh, tell us about, let's slow this down for just a second
Yeah.
because we're wrapping this up. Do you have a charity or a cause or something that resonates in your heart or the heart of your family?
Yeah. I think for me, I mentioned my father, who had a really impactful piece of my life, really formed who I am, I think, as a professional, as a human, as a man,
Mm-hmm.
kind of really gave me the tools to be a good human. He
Mm-hmm.
passed away in 2013, so it's been just almost 13 years now. He
Mm-hmm.
passed away, and he passed away of leukemia, lymphoma, and melanoma. And so I've gotten involved with the Leukemia and Lymphoma Society quite a bit in donating and also in team and training. My wife did quite a few. You should do quite a few runs with them. They do a lot of work with marathons and half marathons to raise money, and I'm still connected with them in that regard as well too. And so that's really
Mm-hmm.
my focus is on my father and his cancer.
Great.
Trying to do what I can to help people extend the lives of their family members. I wish I had more time with my dad. He never got to meet my son, who is named
Right.
after him. So that's the kind of where my heart really lies in connecting with him and people that have, lymphoma, even melanoma, all these different cancers, trying to find a way to, help get people more time.
I love it. I love it. I'm very close to my dad too, so all I can say is I relate completely because he's my hero too.
Yep.
And so just wanted him around longer. It took when my dad passed, instead of celebrating his life, I just became fucking angry for years. God damn it! At my dad's funeral. The priests, everyone's there, and they want me to speak, and I get up there and I just put my hand on the coffin and I was like, why? I mean, it was like a scene from a movie because I couldn't digest it. And then I had another friend who lost his dad 2 or 3 years later, and he's up there laughing and celebrating his dad. I'm going like, that's the way to do it.
Yeah.
That's the way to do it. I'm such a fucking idiot. I'm an idiot. And I said, no more of that. We're celebrating this amazing man. And so
That's great. That's great to hear. I think, having that relationship, my father and I, we used to butt heads a lot when I was little. And it wasn't until I was an adult that we started really getting along. And I didn't have that many adult years with him as much as I wanted. And so that's the biggest challenge I faced with him was wanting to have more time with him when we really got along. And I really get to know him more and have him meet, my kids, and never having that opportunity really inspired me to make sure I take care of my health as best as possible, have the best relationship with my children as possible, and just maximize the amount of time that I have with them.
It's beautiful. So that's great. That's a gift to your father too.
Absolutely.
So
100%.
wait, you being the best dad you can be is a huge gift. And I always say this too. When my dad was dying, I said, I'll see you in the blink of an eye, Dad. Because look at how fast we got to this age. So I'll see you in the blink of an eye. Everything's going to be fine, Dad. And then I was an idiot for a couple of years and finally pulled my stuff together.
No, that's true. Yeah. There's no real right or wrong way to deal with those situations.
It's true.
It's challenging.
It's true. But I look back, I'm very self-introspective. So when I see that, I realize like, what is wrong that I'm unable to let go and then focus so much on anger. That's not what my dad would ever want. Mm-hmm. My dad was a gentle, everyone. If you didn't like my dad, it's like, what? He's that guy. Everyone freaking loved my dad. And he, for good reason, he was just an amazing guy.
That's awesome.
Yeah. I'm glad we got to share this, man. That's nice.
For sure. And I always hear other people's friends and their fathers pass away or mothers pass away. I try to do what I can to support them because I'm intimately familiar with how painful it is.
Yeah. That's another gift. It's like giving a gift to your dad. It's beautiful.